Hey everyone, it's Rob Ryder, April 11th, 2013. A little more on Justices of the Peace. Bobby in Arizona sent this over to me, and pretty telling. Origin of the office. The part played by lay magistrates in the judicial system of England and Wales can be traced to the year 1195. Richard I in that year commissioned certain knights to preserve the peace in unruly areas. They were responsible to the king for ensuring that the law was upheld. They preserved the king's peace and were known as keepers of the peace. The title Justice of the Peace derives from 1361 in the reign of Edward III. An act of 1327 had referred to good and lawful men to be appointed in every county in the land to guard the peace. Justices of the peace, referred to as magistrates, still retain and occasionally use the power conferred or reconferred on them in 1361 to bind over unruly persons to be of good behavior. The bind over is not a punishment but a preventative measure intended to ensure that people thought likely to offend would not do so. For the following 600 years and continuing today, Justices of the Peace have undertaken the greater part of the judicial work carried out in England and Wales on behalf of the sovereign. Most of the time, until the invention of our modern system of local government in the 19th century, JPs also administered the county at local level. They fixed wages, built and controlled roads and bridges, it sounds like the road commission, and undertook to provide and supervise locally those services thought by the monarch and by Parliament to be necessary for the welfare of the country. On behalf of the sovereign, which one they talking about? What sovereign? The king, the queen? Who? Obama? No. Lord Jesus Christ. That sovereign. Commission of the Peace. The present work of Justice of Peace is almost entirely judicial, but certain of their responsibilities for the licensing of premises selling alcohol are retained from the days when they were also regulators and administrators of the counties. An appointment of JP was and still is inscribed by name on a commission of the peace for the county concerned. So go look, if you're in England, go find the commission of the peace and you'll find out who all your they should have an index, commission of the peace. Go find out who they are. It was as members of the Commission of the Peace that justices became virtual rulers of England and Wales at the local level. Don't argue with it. Justice of the Peace, rulers of the local level. For centuries, those appointed to the commission were either landowners or merchants of great substance, whose social position and economic power was so strong that their authority went undisputed. It is reflected in matter that even today JPs hold no badge or certificate of appointment. See, we're going to become our own justice of the peace. We're going to become the highest level conservators of the peace. More on that in another one from a lecture given by, what was the guy's name? Did it in Oxford. Anyways, that'll be another video. Quarter sessions. Act of 1361 provided that JP should meet to conduct local business 4 times a year. This was the origin of the quarter sessions, which continued until replaced by crown courts in January 1972. Although they retained their original name more than 600 years, many of them were in continuous session in the closing years of their long record. Yeah, had lots of problems in later time. They always were in session. The great unpaid. This is where it gets interesting. These guys already have their estates. The JPs are often referred to as the great unpaid. In fact, under Act 1389, the early justices received a subsistence allowance of 4 shillings a day. This appears to have lapsed, presumably because for centuries most JPs were well-to-do landowners who would not bother about expense accounts. They were tough on poachers. So as many of these first JPs were landowners, it is not surprising that as early as the 1389, the first game law was passed. The old JPs had a reputation on being tough on poachers, who were usually well known to those before whom they appeared. So who are these poachers now? Right? It's the guys trying to take your property. They're well known to the justice of the peace, and they will be tough on poachers. Powers to fix wages and services. The administrative duties of the JPs began to develop in the closing years of the 14th century and continued till 1888. As early as 1389, they acquired power to regulate wages and control the cost of living by fixing prices. Ain't that interesting? They get to fix prices. The act provided that victuallers shall have reasonable gains according to the discretion and limitations of said justices. They're going to determine how much money you get to make. So long as the economy was predominantly rural, the pressure on both wages and prices came from such natural causes as inclement weather and poor harvest. Such factors as cost of land and buildings hardly entered into the reckoning. The establishment of industries in medieval wool towns brought new problems which the JPs were ill-equipped to deal. Most of the new employers were in competition with landowners for labor. Legal qualifications of justice of the peace. Much has been said about justice of the peace being untrained until recently, but in fact many landowners were members of inns of courts. If you live in a halfway decent sized town, you have an inn of court. Grand Rapids has one. It's where men were learned in the law. You don't learn jack about the law in college. You just become a practicing attorney. You want to learn the law, you go to inns of court. This, however, was not to assist them in administering the criminal law, but to equip them for the prudent management of their estates. I might have to go join me in a court. Figure out how to administer that estate. Didn't say execute the estate, did it? It said administer it. Okay, I want to learn to administer my own estate. Usually, their study of law did not go very deep. Shakespeare, Master, Shallow, and Falstaff were typical. They were roisterous fellows whose fondest memories are summed up in Falstaff's line, "We have heard the chimes at midnight, Master Shallow," whatever the hell that means. For all that, at least 50 editions of works for the guidance of justices have been published by 1600. 50 different editions about what justices are supposed to do. And so effective had the rule become that Sir Edward Coke described it as such a form of subordinate government for security and quiet of the realm as no part of the Christian world hath the like. In 1576, JPs were required to build houses of correction, in which rogues and vagabonds could be detained. These were apprehended by village constables, unpaid parishioners, conscripted for service annually. This is in the Protestant reign of, this all after Henry VIII, right? So, this is what the Protestants did. Let's see what's going on. The Reformation, followed by altering the Catholic and Protestant ascendancy, affected the justices as well as every other section of the community. JPs had their names removed from the commission for non-attendance at their parish church. Oh, now they're going to tell you they have to go to church. That was the Reformation. You have to go to church. You want to be a justice of the peace. A screening operation carried out by the bishops revealed that 850 JPs examined, more than half were suspect of being recusants. A purge followed in 1579. Every JP was required to swear fidelity to the established religion. In other words, they had to take an oath to the national religion set up under the Reformation. Confidence was temporarily restored, and when the Spanish Armada threatened England, the justices again proved fully capable of maintaining the Queen's peace. Now we got the Queen's peace. I don't want the Queen's peace. I want to go back to the King's peace. The system under pressure. In the third quarter of the 16th century, the rural JPs began to be questioned. It was alleged that many of them neglected their duties or were incapable of performing them. In the words of Elizabeth is Lord Keeper, Her Majesty may be driven, clean contrary to her most gracious nature and inclination, to appoint and assign private men for profit and gain sake to see her penal laws be executed. And we got penal codes, and that's what we're trying to get executed. Okay, so maybe nature and inclination to appoint and assign private men for profit and gain sake to see her penal laws be executed. So these are what the district attorneys are. They're private men for profit and gain, and they're going to, charge you with a penal code of one kind or another, because anytime they charge you with a violation, right, it's a violation of a statute, penal law, perjury. Right, anytime they say you made a false statement, I don't care what else the paper says, that's perjury. And that's a penal law. So if we're not going to do it, they're going to hire private men to do it. At the same time, it was acknowledged that many were conscientious. These, however, were said to be overburdened and unable to meet the increasing demands of their office. So what did they do? Well, they expanded their duties. Already couldn't do them, and I will give them some more. 1590, a new commission was introduced redefining the duties of the JPs. 7 years later, they were given responsibility for the administration of the poor law. Sounds like probate, maybe. What would the poor law be? Meanwhile, our duties in operating the criminal law. Oh, that's a bankruptcy. That must be what that is. Bankruptcy law. Yeah. To administration of the bankruptcy. Meanwhile, their duties in operating the criminal law were increased so rapidly that somebody's work on the duties of justice peace ran to over 700 pages. The most controversial ordinance affecting justice JPs was an act of 1652 empowering them to perform marriages and making all other forms of the ceremony illegal. So justice of the peace, that can perform a marriage, anybody who can perform a marriage and says that they're justice of the peace, you can take your complaint to. When this exclusive right repealed, it became necessary to regularize the position of those already married by JPs by providing an act something such marriages were held to be valid. Under the Commonwealth, the social distribution of appointments widened. Okay, so appointments. These are elected and appointed positions. There were fewer noblemen and more esquires in the commission. Fewer noblemen, fewer royal men, which is what we should be, and more esquires, which is what attorneys are. This 10, however, was reversed in the Restoration. The nobility returned to power and were the instruments of the crown in enforcing measures against dissenters. They enforced uniformity in worship, as our forerunners had done under Elizabeth I, but religious fluctuations again brought confusion. James II tried to pack the commission with his adherents. So this is, Catholics and Protestants trying to run the church. Who's going to run it? Whoever the sovereign is, right? That's basically the religion that was going to be enforced. Sounds like they want to go to the prayer book. They enforce uniformity in worship. That would be the prayer book. The Revolution of 1688 brought radical changes. In 1700, 74 Middlesex justices removed from the commission. Property qualifications rather than political or religious allegiances carried weight. All right, so now it didn't matter who you knew or what faith you had, but how much property you had. In 1732, the property qualifications which had remained commission, property qualifications rather than political or religious allegiance carried weight. Remain commission, which had remained commission. Property qualifications rather than political or religious allegiance carried the weight. In 1732, the property qualifications, which had remained unchanged since 1439, was raised. It was held 12 years later that it was of the utmost consequence to provide against persons of mean estates being appointed. The Lord Lieutenant appointed only men of substance and of recommendation to the crown. In the second half, I don't know, like there's parts missing from this thing that I cut and pasted. As early as 16th century, JPs had divided themselves into local groups to deal with vagrancy, poor relief, etc. So there's quite a few justices of the peace, it sounds like. They're not all sitting in a court necessarily. They're men of substance that have been appointed to be justices of the peace. This is why I think that now here we have county commissioners who are over districts, and each district has about the same number of people in it. And that took over for the duties of the township supervisors. Because in Michigan, we should have a board of supervisors made up of all the township supervisors running the county. And we don't have that. What we have are county commissioners over districts having about the same number of people in each district. And I think that's who the lowercase district judge is. But that's just one level of justice of the peace. And that's the guy we need to go to establish our, to become a registered elector within the district, because it's no longer a township. Now it's a district. In fact, in the Michigan compiled laws, when you read, actually in the Constitution, when you read, I think it's Article 7, Section 7, it's talking about the township supervisors. It has in the compiler's notes that that section of the Michigan Constitution had been determined to be unconstitutional by the federal government. And I did a video on that and what that led to, and it led to these districts having about an equal number of people in each one. Okay, so they divide themselves into local groups to deal with vagrancy, poor relief, etc. So these would be, if you were to look in your county and find anyone who's a freeholder or a householder or some other words they might use, it's a good chance that either they are a justice of the peace in one form or another, or their family members are. 19th century, the movement of population to the towns brought new problems. The county families moved out of the newly urbanized districts into neighboring countryside. The trading justices, chiefly associated in Middlesex but were also prominent in Lancaster, came in. So you got trading justices and you have these county families. Landowners and merchants. In the second half of the 18th century, a large number of clergymen had served as justices. Some had, in fact, been chairman of quarter session. I don't know what the chairman of quarter session is, but he must be like a chief justice of some kind. The Reverend somebody held a valuable living worth so much was probably the first. Another was chairman of the quarter session and published in 1755 his great work, The Justice of the Peace and the Parish Officer. The edition published in 1869 was in 5 volumes. That'd be an interesting read. During the change from rural to urban conditions, many of these clerical justices played a prominent part, partly in improving conditions of the county goals, the county jails. In 1832 of the 5,300, 1 in every 4 was in holy orders. Go figure. And that makes sense. I was watching this video, and it was some guy standing up he was in front of a congregation in a church, but they were having a meeting of some kind. So it could have been in wherever they would have a meeting in this church. And he was a judge talking about different forms of law. And I think what they were trying to do is convince these people that they had to get how to protect themselves from lawsuits. That's what it was. Well, the next day, in the same series, another guy gets up and he said, I want to thank Bishop so-and-so, Judge so-and-so. And it's like, well, he just said that judge was a bishop. And he's a bishop of some, congregation of a church. Well, he's also a judge in Tennessee. I bet you he's a chancellor. Between 1829 and 1888, the JPs were relieved of some of their major administrative duties, with the exception of liquor licensing, which was thought widely that they would soon be relieved of their judicial duties also. Some historian wrote, the JP is cheap, he is pure, he is capable, but he is doomed. He is to be sacrificed to the theory on the altar of the spirit of the age, which was money. Since he wrote those words, the judicial responsibilities have increased almost annually. They didn't go down, they got bigger. And the reason for that is these private attorneys are using God's law against you. They're saying you committed a sin. Right? You didn't, everything's about a promise, right? Did you sign this deed of trust? If you say yes, well, then that was your promise to do the deed of trust. If you don't say, yeah, I signed it, where's the bank signature? I thought we had a contract. That just brought it into equity. Chancery has jurisdiction over contracts. The effect of progressive urbanization. Before 1835, justices in towns were appointed in accordance with rights granted by charter. The Municipal Corporations Act provided for them to be nominated by the Lord Chancellor for the boroughs in consultation with local advisors, while for the county benches he continued to confirm nomination of the Lord Lieutenants who had their own methods of finding suitable candidates. The appointment of both was vested in the Crown acting on the Lord Chancellor's advice. The exception of the rule was Lancashire, which both county and borough magistrates were nominated by the Chancellor of the Duchy. Okay, we got the Lord Chancellor. He's involved. Was normally a cardinal. Right, sits in Westminster Abbey. The system of appointment changed. The Liberal government. So, while other people may select them, right, everybody falls under the Lord Chancellor. And the Lord Chancellor is over the Court of Chancery, the Court of Exchequer, and the Court of Common Pleas. He doesn't necessarily sit in any of them. That's what he controls. The Liberal government of 1906 challenged this system of appointment, which led to preponderance of conservations on the benches. The property qualification was abolished for county magistrates. Liberal Lord Chancellor nominated 7,000 magistrates between 1906, of whom 3,197 were liberals. Well, I wonder what a liberal means. I think it means they weren't a landowner. Because before that, you had to have a certain amount of property. The Royal Commission on the Appointment of Justices recommended the institution of the advisory committee system, and by the end of 1911, advisory committees, on which liberals and conservatives were usually equally represented, had been set in most counties to advise Lord Lieutenants on nomination. I wonder who the Lord Lieutenant in the county is. Probably the chief judge of the county. 10 or 12 years later, but he's actually sitting on the road commission because they have jurisdiction over roads, and he can do marriages and I guess. 10 or 12 years later, the boroughs had formed advisory committees. Appointment of these committees was for life until 1925, when Lord Cave introduced appointment for 6 years and ordered half the committee to retire by rotation every 3 years. So it used to be for life, and now they're appointed for 6 years at a time. The system of administration of justice by lay magistrates is more than 600 years old, but it was not until 1920 that it was proposed to establish an association of magistrates. The idea came from Adderman Wilkins, a magistrate for Derby, and the invention of Lord Mayor of London. About 200 magistrates met. Okay, so we're going to make this association. The association is governed by a council composed by members. Okay. It is held in the Home Office on, which 29 members were present, was held at the Home Office on 25th of November, 1921. I wonder if 25th of November is still an important date to this association. Although its early years, the association members were fairly small. Oh, and by the way, the Magistrates Association, it still exists. If you're from the UK, this is mainly written about the UK. You want to find a Justice of the Peace, you've got to find the Magistrates Association. They're going to have a list of members. The association encourages members to undertake basic training immediately upon appointment to keep up with changes to law and procedure. It was not until 1949 when the Royal Commission drew attention to the subject and the real importance of training was recognized by the government. Most of the Commission recommendations regarding training were implemented in the Justice of the Peace Act of 1949. Something else good to read, which provided that the Magistrate Courts Committee should make and administer schemes of instruction in accordance with arrangements made by the Lord Chancellor. And its inaugural meeting, there were 500. They ended up, they kept getting more. The association membership was 28,000. This is in 2001. The association's membership was over 28,000, of which 26,000 are active magistrates. This is in the UK. You got 26,000 magistrates. Go find one and give him your complaint under oath. He's the one that can take your oath. The association can claim to represent 85% of the magistrates on the bench as well as on the supplemental list. The association was granted a royal charter in 1962. Now they're commissioned officers of the royal officers. And they're assigned a coat of arms. Under the charter, the Lord Chancellor of the day is ex officio president of the association, the Lord Chancellor, highest ranking man in the kingdom. Since the king is not here, he is the king's conscience, keeper of the keys. Keys of the kingdom. The proper magistrate has the cipher to untie the Gordian knot of conveyances that keep you as a bondservant. President of the Association, Lord Mayor of London, ex officio vice president. Okay, training of magistrates. The changes introduced by the Criminal Justice Act and the Justice of the Peace proved, so far reaching that 1953 a system of magistrate courts committees was established with responsibilities for administering magistrate courts and engaging staff and providing courses of instruction for justice. I got to go back to the Magistrates Association. The Magistrates Association, right? Got 26,000 magistrates. If you're in the UK, go to their website and find out who the magistrates are. Take him your frickin' complaint under oath. He can give you the oath. You just need to provide probable cause evidence. And the easiest one is they've never given me whoever's charging you hasn't given you a complaint under oath to say you've done anything wrong. 10 years later, anxiety was widespread about the failure to fulfill their training functions adequate scale. Okay, so we got to get them better trained. Got to train them up. And so they made it compulsory in 1966. We had this Justice of the Peace Act. This act provided for a gradual reduction in the age retirement, confirmed position of clerk as legal advisor to justices. Okay? The position of the clerk as legal advisor. So the clerk is a legal advisor to the justices. We're not saying what clerk. But this has to be the court administrators they're talking about, because they work for the justices. I think here they would be called the court administrators. The fact that 98% of all cases which come before the criminal courts of England and Wales are disposed of by JPs with no required legal qualifications continues to surprise many people. They don't have to have any legal qualifications. They don't need to be an attorney to be a justice of the peace. The justification is based largely on the relationship which has had developed over the years and in 1968 received statutory authority between JPs and their clerks. So the clerk of the judge, I think, is the one they're talking about, not necessarily the circuit court clerk, but the judge's clerk. The JPs bearing sole responsibility for their findings on the fact and on credibility of witnesses, the clerk advising them on the law and extent of their powers. The clerk knows the law. The JP is going to use common sense. The Court Act of 1971 drastically altered the legal system, which had continued for 600 years, by providing the abolition of the assize and quarter sessions and the replacement with a new Crown Court. In a presidential address to the association, Lord Halesman described this as by far the biggest measure of law reform in this particular field for at least a century, and in some respects since the institution of the assize system in the reign of Henry II. Biggest thing in 600 years, the Courts Act in 1971. It was concerned mainly with the reorganization of the higher courts, but it was important for JPs because it enlarged their powers by enabling them to exercise full jurisdiction in the Crown Courts over the whole of England and Wales. They're all JPs, or just different levels. They hold the office of Justice of the Peace. A judicial officer with limited powers who, okay, so now this is just a definition of a Justice of the Peace. A judicial officer with limited powers whose duties may include hearing cases that involve civil controversies, conserving the peace, performing judicial acts, hearing minor criminal complaints, and committing offenders. Hearing minor criminal complaints. How are they going to hear it? You're going to take it to them. This isn't talking about in court hearing. This is, hey, I'm bringing you a complaint under oath, and here's my probable cause. Go investigate. Justice of the peace are regarded as civil public officers. I'm just a public servant, the dude told Rich. Distinct from peace or police officers. Depending on the region which they serve, justices of the peace are also known as magistrates, squires, and police or district judges. In some districts, such as the District of Columbia, justices of the peace are considered officers of the United States. I'm going to say that's the dudes called the magistrate judges, who are Article 4 judges sitting in Article 1 court. They're in the bankruptcy court. In other regions, their jurisdiction is limited to state, city, precinct, county, or township. Right? There are many justices of the peace, and depending on who they are, they have a limited jurisdiction. Some over the entire state, some over a section of the country, some just in your township, some just in your city. But they're still a justice of the peace. The position of Justice of the Peace originated in England in 1361 with the passing of the Justice of the Peace Act, the colonial America, the position with its judicial, executive, and legislative powers. So now, these Justices of the Peace, there is no separation of powers. They have judicial, executive, and legislative. Was the community's main political force, and therefore, well, no doubt, they had all the frickin' power. So they were the main political force, and therefore the most powerful public officers open to colonists. Legal training was not a prerequisite. It's the most powerful public office, a justice of the peace. Go figure. Maintaining community order was a priority in the colonial area. The justice of the peace in this period was responsible for arresting and arraigning citizens who violated moral and legal standards. By the early 1800s, crimes handled by the justice of the peace, including drunkenness, adultery, price evasion, public disorder. Justice of the peace also served on community court staff members and heard grand jury and civil cases. All right, so the grand jury hands down an indictment. A justice of the peace is going to hear the case. And when you say in open court, I motion the court to its equitable jurisdiction because this grand jury indictment is simulating a legal process, and that's a crime. It's really all you'd have to tell them. Nobody has filed a valid complaint under oath that you've done anything wrong. The bank hasn't, the police don't. Now, if you actually hurt somebody, that'd be different. But if you're driving down the road, you got expired tags on your car, they pull you over, what did you do wrong? Really, nothing. That cop is not going to put anything under oath that you did anything wrong. They're going to simulate a legal process. The bank is going to simulate a legal process. That's all they can do. The increasing number of criminal, slave, and tax statutes that were passed during the 1800s also broadened the enforcement powers of the Justice of the Peace. Criminal, slave, and tax statutes. Today, Justice of the Peace deal with minor criminal matters and preside over the lowest only in the lowest state courts. Preside only in the lowest state courts. Their legal duties encompass standard judicial tasks such as issuing arrest or search warrants, performing marriage ceremonies. They can do a marriage. They're a justice of the peace. Handling routine traffic offenses, determining probable cause. Well, how are they going to determine it? You're going to bring them a complaint. Imposing fines and conducting inquests. They're going to investigate for probable cause. The duties of the justice of peace vary by statute, and it is the justice's responsibility to know which actions are within the scope of his or her jurisdiction. For example, a few statutes do not allow justice of the peace to be involved in the operation of another business or profession. However, they can invest in, it has nothing to do with their powers, it's what they can do outside of their powers. Conflict of interest. Justices are often considered conservators of the peace. They can arrest criminals or insane people, order the removal of people who behave in a disorderly fashion in a public place, and carry out their duties designed to maintain and restore a peaceful community. Justices of the peace have limited power in criminal and civil cases. They have jurisdiction over minor criminal matters, including misdemeanors, infractions of petty offenses. Their powers in civil jurisdiction are determined by respective statutes that govern their position. So here it says in the what we call our district courts, we have circuit courts and then district courts. It's where traffic cases are, basically. That's where these justices of the peace are. And it says on many of these district court websites that is where all criminal proceedings begin. And from there, if it's too big, if it's a felony, it goes up to the circuit court, to a higher level justice of the peace. At the highest level, a justice may handle cases that involve contracts, torts, injuries to personal property, personal injuries such as libel, slander, false imprisonment, malicious prosecution. Justice of the peace do not have jurisdiction over cases that involve real property, titles, easements, or right-of-ways. There you go. They do not have jurisdiction over cases involving real property titles, easements, or right-of-ways. That's all law stuff. What they have jurisdiction over is all equity. A tort is an equitable claim for damages, contracts, good faith, injuries to personal property. They've taken my property. The personal injuries such as libel, slander, they slandered your good name, falsely imprisoned you, malicious prosecution. Right? All these are something other than, and including a money damage, but law can only give you a money damage. Equity can give you all these other things. Depending on the tradition of the area where they serve, justice of the peace are either elected or appointed. The method which reached their office has no bearing on how much power they have. Doesn't matter how they got there, they all got the same power. Appointments are typically handled by the state's legislative body or governor. However, this task may be delegated to local authorities such as county supervisors or commissioners. So they're going to appoint them. Interesting. But if they're appointing them, these supervisors or commissioners must already be them. They're just appointing more of themselves. Once elected or appointed, and before taking office, a justice of the peace is required to take an oath and post an official bond. Some statutes also require new justices to sign a sworn statement that they have never been convicted of a misdemeanor or felony. Well, neither have you. You may have been charged with one. You may have done time for it, but if you go online, you're still a defendant. Case is still open. The case is never closed in the civil courts. That's why we need to go back and clear our good name. Because they committed slander. Nobody put in a complaint under oath to say you broke any laws. That's so profoundly simple, I don't know what the problem is, right? If nobody will put in a complaint against you under oath, do you need to read that someplace? It's all over the place. You can't find it. It is all over the place. But do you really need to read it for that to be frickin' common sense? Right? What they did is they just they got us looking in the wrong way. They think they got you going to a guy called a public prosecutor or to the sheriff or to the police desk, right? That's not where you take your complaint. You take it to a justice of the peace. The length of term of justice of the peace varies with the Constitution or statute. Okay. Vacancies created. Replacement of justice of the peace usually completes only the remainder of the term and serves until the next scheduled election. Justice of the peace can be removed from their position for a variety of reasons. Now, these elections, I don't think that we're involved in these elections, right? These elections are done from within by these commissioners, right? The commissioners are the ones who do the elections. They call it an appointment, right? But you get a board of commissioners together and they raise their hands. Who thinks this guy's good? Boom. Now they give him the appointment. He was elected by the commissioners. Show of hands. Justice of the peace can be removed from their position for a variety of reasons, including official misconduct or conviction of a misdemeanor or felony. So if they make a willfully false judgment, which is another thing you could say in court, if this case was to continue, all that could happen is a willfully false judgment based on the perjury of the witnesses. Because if you have a complainant witness and somebody signed and take an oath that they're the complainant witness and there's no complainant, the guy just committed perjury. Usually the statute that defines position will outline the procedure for removing justice of the peace, ordinarily a justice served. Yeah, okay. You can read about that stuff. If a justice of the peace wishes to resign, he must present a letter of resignation to the appointed official, and once it's accepted, it cannot be withdrawn. Okay. Just a few definitions. Bill in chancery practice. A complaint in writing addressed to the chancellor containing the names of the parties to the suit, both complainant and defendant. I call him respondent, but I call him defendant from now on. A statement of the facts on which the complaint relies and the allegations which he makes with an averment that the acts complained of are contrary to equity, and a prayer for relief and proper process. Its office in a chancery suit is the same as a declaration in an action at law, a liable in a court of amity, or an allegation in a spiritual court. So this is where the chancellor in Tennessee wrote. He said a declaration is a graven image, and a declaration is put into a court of law because it's all fiction. Courts of law are where your estate is the defendant. It's your all capital letter name. The property's the defendant, and you're just its attorney. If you go in pro se into a civil case, you are the defendant's attorney. I don't want to be the defendant's attorney. I want to say that's my property. I'm the owner. And you do that by going to chancery. Because what they're doing is contrary to equity. They're trying to enforce an illegal contract, simulating a legal process, using threat, coercion, and duress. Well, that's shit that chancery cares about. But courts of law don't. Complaint. One who makes a complaint. Or complainant. One who makes a complaint. A plaintiff in a suit in chancery is so called. What is he called? The complainant. What's the name of the document? A complaint. Complaint, criminal law, the allegation made to a proper officer, that justice of the peace, that some person, whether known or unknown, has been guilty of a designated offense, with an offer to prove the fact and request that the offender be punished. To have legal effect, the complaint must be supported by such evidence. Probable cause shows the offense has been committed and renders it certain or probable that it was committed by the person named or described in the complaint. And the evidence we're giving them is their self-confession, such as a deed of trust that doesn't have a signature on it, a title insurance policy that says that the title insurance company insured your title in fee simple, yet the real estate transaction has never closed and you've never gotten your fee simple title. Therefore, they have a duty to defend your title. you never got your fee simple title. And that's what you got the insurance for. Okay, so that's about it. It's called a complaint. It goes to a justice of the peace. You put it under oath. You give them probable cause by providing some evidence. And then what happens is, once you have put a complaint under oath and given it to the justice of the peace, then the defendant, he can either acknowledge that yes, you are correct, he broke those laws, or he can deny it. If he denies it, he has two choices. It can either be what's called judicial combat or the verdict of a jury. That's his two choices. So if he won't go to court to be held by the verdict of the jury, then his only choice is judicial combat. And I wonder exactly what judicial combat might mean. I wonder if that's where some of these people end up having heart attacks and stuff and accidents or whatever. If they're just a victim of judicial combat because something was put in to chancery and they denied the charges, yet they wouldn't go before a jury. I wonder if that's that's the things hiding in the back, and why the chancellor in Tennessee said that to defy the court of chancery shall bring the thunderous wrath of the Vatican upon you. And you get to the court of chancery by putting a complaint in writing, chancery practice, addressed to the chancellor. Don't really know how to do that yet. My suggestion is, in fact, I was talking to Bob in Massachusetts yesterday about this. What are we going to call the court? Let's just call it the one court of justice, right? In Michigan, in the judicial section, it says there is one court of justice. So I'm going to call it the one court of justice. So it would be to the justices of the one court of justice. In equity. Okay, so, I don't know how much more I can ever say about who it is. It's the justice of the peace. They're there to preserve the king's peace. I can claim the king's peace. I can be a conservator of the peace when I claim the king's peace. I'm the highest ranking conservator in the kingdom outside of the king when, as a subject, I claim the king's peace. And I bring the charge as a private prosecutor to a justice of the peace, who then becomes the public's attorney or the public's prosecutor, and he goes and investigates, and if he finds probable cause, which could be as simple as you giving him the information and your sworn complaint, he then goes to another justice of the peace as the trier of the fact, and between the two, they believe it to be what it is. They both put their seals on it or sign it, and now you have a quorum. You had two justices agree that the crime has been committed with a court seal, and now they can issue a lawful warrant. And now they go to the defendant and said, you got two choices. You can either acknowledge the crime or you can deny the crime. If you deny the crime, you have two choices. You can either have trial by jury and accept their verdict, or you can have judicial combat. Which would you prefer? We have all the guns. Good stuff. All right. See y'all later.